Real words about talking to judges and the other side when sued for debt. Brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. If you're being sued for debt and representing yourself, and that's called pro se, you're going to have to talk to judges and also to the lawyer for the other side. That isn't as scary as you may think, but it presents special challenges for pro se defendants, and particularly pro se debt defendants. The first thing you must remember is that any factual thing you say can be taken as an admission. That means if the fact that you made the factual statement is established, the fact itself will be regarded as proven. And that can be huge in debt cases where debt buyers often cannot prove things with legitimate evidence. If you say, I know I owe, or I know I did, or you told me, or anything else that leads to a factual statement, that fact will be regarded as proven, not for you incidentally, but against you. So don't try to get cute and say, for example, I know you can't prove your case. The rule only applies to what are called admissions against interest, and it's a one-way street. You can't make admissions for the other side. Is that clear? Now let's talk about judges. When you're talking to the judges, they may simply ask you, for example, whether you used or had a credit card or had an account or something along those lines. You may be disputing mainly whether the debt collector has a right to collect from you, which could be a completely different issue. But if you admit you got the credit card or had the debt in any place to anybody, you will lose the case 99% of the time. You're just going to have to take my word on that. You must resist the temptation to answer such a question with an admission. You can say instead, that's one of the things the other side has to prove, and I'm not admitting it. You are not a witness under oath when you're talking to the judge in open court unless you are in fact testifying, and you should not feel required to make admissions. If the judge presses you very hard, simply say you don't think so. If the lawyer for the other side asks you point blank for some similar admission while you're negotiating or haggling over discovery, or at any other time than while you're under oath, and they do this sometimes, you should simply say you deny it. That's what you're doing by your denial of the allegation and your answer. Now, let's go on to some unwritten facts that you as you might call them, and they're frankly not going to be pleasant for you to hear. But you need to know this bit of the background. Both judges and the other side, lawyers and their minions, regard you as socially inferior. You may feel it and feel intimidated, or you may not even feel it, but most of the time it is a simple fact. They do not respect you in a fundamental way. With judges, that can never be remedied. They can respect your intelligence and your willingness to compete, shall we say, but they are in a position of power over you that is virtually absolute, and they've been in that position or some similar position for a long, long time. This gives you a kind of delicate task, which we'll come back to in a minute. But first we'll talk about the lawyers and the other side generally. The lawyers don't respect you either, and neither, most especially, do their owners, the debt buyers. Again, you can't fix that, but you must treat them as much as you possibly can as your equals. They're not your parent and will never, under any circumstances, do anything in your interest that doesn't help their interests. So don't ask them for guidance in any way. Ask me, or ask a trusted friend. And then do your own research. But when you're talking to the lawyer, you should be aware of the power dynamic and resist it. Not saying be rude or overbearing. I'm saying to keep your cool and treat the lawyer the way you'd treat anyone else you're in a professional relationship with, because that is what you're in. Believe me, though, they start with contempt for you, and that will never change unless you fight and win. Professionally, again, I emphasize, you fight and win by standing up for your legitimate rights, keeping your cool, not making admissions, and forcing their hand where possible. Eventually, if you do these things, they're likely to develop a sort of grudging admiration for you. Fighters do like fighters, after all, in a way. They respect that about each other, but they're never going to invite you to the boathouse, if you know what I mean. Now let's get back to judges, because your relationship with them is much more complicated and more important. Your job as an advocate is to instruct the judge on what the law requires as you understand it. If the other side is suing you for a debt they cannot prove they own, even own, you have to tell the judge that the failure to prove ownership requires that they lose the case. When you object at trial or in motions, for another example, you will have to tell the judge why legal precedent in your state requires that your objection be sustained. You're telling the judge what to do. Lawyers do this all the time, although even lawyers handle judges they don't know extremely well with kid gloves. You got to be careful because they do think of themselves as gods. And your job is that much harder because the judges regard you as socially inferior. You still have to tell the judge what the law requires, and you can't mince your words about that, but never, ever interrupt the judge, raise your voice, or lose your cool. And don't forget that judges can make mistakes in good faith, and so can you, of course, so work with that. It doesn't mean they're against you. It doesn't usually mean much of anything if they rule against you on something. It's usually impersonal for them, and even if it isn't, you have to act like it is. Remember that judges are in a godlike position over you, and a lot of them seem to think that they are God, too. I think I mentioned that. If they tell you to shut up or it's over, or they've ruled on a question, they expect you to thank them. They do, and it's standard. The judge says, "I've overruled your objection," and you say in response, "Thank you, Your Honor." And then you sit down. It could seem disgusting, but it's tradition as much as anything else, and you are respecting their position when you say that more than their person. You have a challenging balancing act with judges between making your arguments and recognizing their authority. You have to tell them what the law requires and what makes you think so, and they actually may not know or remember. But remember that when they make their ruling, you just have to accept it for the time being. With all that said, a lot of judges are intelligent, nice people. All of them are, at least some of the time, to some people, and try to see that part of them. Recognize that fact and understand that judges play a role in your case, and that role is to make judgments, some of which you aren't going to like. Don't personalize their rulings, and don't think that because they disagree with you on some point that they're against you. Unless you're a competitive athlete or a lawyer, this is probably way out of your normal experience in life. But referees in football are required to look at every play and make their best judgment, regardless of who they like better. They try to do that. And so do judges most of the time. Understand that fact. It's just their job. Now let's talk about you a little bit. When you're talking to the other side, but especially when you're talking to a judge, remember to listen carefully. So often people just listen to what others are saying, primarily as a way of marking time. You have something you want to say, and you're just waiting for them to finish so that you can say it. Don't do this in the law. Listen to what they're saying. It's usually important. And make sure the things you say are important too. Stay on point. And remember that anything you say that seems to go off point will cost you respect and attention. As a pro se defendant, you don't have much of that to spare. No one wants to hear your feelings or difficulties. They want to hear what the law is and what it requires. If you're representing yourself, you're going to have strong feelings, but keep them in check and keep them quiet. Talk about the few things that matter to whatever you're discussing. That's being professional, and it will earn you respect. Keep it as brief as possible, and I mean this very seriously. Remember that above all, the case that means so much to you means very little to the other side or to the judge. It's just a job to them. It's just money for the debt collector, which they may take more or less seriously, but for you, it's much more important. Act like the case is important to you and work steadily and hard and stay humble. Hope that the judge will take his or her responsibilities seriously enough to be fair and listen to you when it matters, and that the lawyer on the other side is as uninspired as most of them are. Keep these things in mind and you'll have a great chance to win. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. YourLegalAgUp.com